Well, we have to assess this under the law of state responsibility. When is the state responsible for an unlawful attack that can give rise to the right of self-defense against that attacking state? And the law of state responsibility in 2001 was in some state of flux. The International Criminal Tribunal for the former Yugoslavia had weakened the rule that prevailed from the Nicaragua case from the International Court of Justice and said some coordination between a government ineffective control and a body carrying out, an organization carrying out an unlawful action was enough, some coordination. Whereas the International Court of Justice has come back and said, most recently in the Congo case, that it must be the control, that the government in effective control must control that organization to be responsible for its unlawful actions. And the British, who put out a white paper about the links between Afghanistan and the Taliban before they joined with us in collective self-defense on October 7th, 2001, made a case for that coordination at the least. We've now looked at the facts of the British white paper and they look quite flimsy. So I think the facts that we had, that I relied on for an article that I wrote defending the use of force against Afghanistan under the classic law of self-defense, I now have to re-examine and question whether it really was strong enough. I also, frankly, even if the case were better under both the law and the facts, I think it was a mistaken policy. I truly think that we would have gone much further in deterring Al-Qaeda and breaking down that organization if we had used classic police measures against Al-Qaeda after 9/11, much in the same way that the British did after 7/11, as the Spanish did, as the Indonesians have done, as we ourselves did after the Cole attack in Yemen and after the embassy attacks and the '93 World Trade Center bombing. In all those cases, arrests were made, people have been tried and imprisoned, and effective measures have been taken against these organizations. As we heard at the lunchtime talk about the IRA, these are not as dramatic, and people like to see actual big actions against such terrible events as 9/11. But if you want to be effective, you have to be cautious, you have to be careful, you have to use the right tools. And for Americans, that's very hard. We're emotional, we're active, we want to respond.
Can I just
But
take that for a second?
if I could, so that's where I would say, even if we didn't have the law on the right of self-defense, we had always the means of police measures to react against terrorism, and I think that even if we had the other right, would have been the better way today. Professor Fletcher is keen to respond.
No, I don't know whether we want to have a discussion or we want to continue making speeches. I think it would be better to have a discussion, which means we have to keep it short. I just want to know...
I'm sorry, was that a speech?
Well, I can make a speech too, if you like. It's not a problem. But then I just would like to know, and I think it would be good just to keep one point in focus. So I'm a little naive about these things. I want to know why you insist that only state actors can generate a right under Article 51. Did you say that in Article 51?
The right of self-defense, if you're using military action, as we did in Afghanistan, is against the territory. We took action on the territory. So the state has to have a responsibility before we can take action against their territory. If terrorist organizations were out in cyberspace, we wouldn't have to implicate another state's territory. But if you're going to use military action on some state's territory, you must have the right to do it. Otherwise, you're violating that state's right, and you're violating the charter against them.
I think the argument is that if they can't control their own territory, then someone else has to intervene in order to be able to control it.
And we could have taken lower level police action against them, but the level of military action that we took against Afghanistan had to have an Article 51 basis before we could do it.
But I asked you about Article 51. So the question is why, so this is the critical question of understanding the Israeli defense against Palestinians. Is the wall illegitimate? Now the International Court of Justice applied something like your argument and said that the right of self-defense only exists against state agents. The Israeli Supreme Court disagreed and took a more differentiated approach to the legitimacy of the wall, looking at how it functioned in a particular context. Now, it strikes me as a rather important question, because if it is the case that you can only use force against state actors, I think international law has become rapidly irrelevant.
The rule is that the state has to be responsible. It has to be responsible for controlling the actions of the terrorist group. They have to take effective actions. There's international law against terrorism. And there may be lower level rights to take action against a state that is not suppressing terrorism on its territory. The International Court of Justice was, of course, quite right in the Wall case. What they simply said is that Article 51 of the UN Charter is inapplicable to a state that's in occupation, which Israel is in the Palestinian occupied territories under the Geneva Conventions. Then you look to the law of occupation to regulate the amount of force that the occupying power may undertake to keep order. You don't look to the UN Charter. That would be like the United States if we had to bring out troops, which we did in Los Angeles and other places, to suppress violence, we would invoke Article 51 of the UN Charter. Ridiculous.
You may be right, but as I recall, the Israeli Supreme Court in the 2006 decision recognized the conflict as an international conflict, and that the Geneva Conventions apply in order to justify targeted assassinations. Now, if this is simply police action in occupied territory, I don't believe, well, you tell me, I don't believe you can justify targeted assassinations. But under Article 51 sub 3 of one of the conventions, you can use deadly force against civilians insofar as they are engaged in an attack against your forces. So this is a kind of middle zone between regulation of law enforcement and the law of war. There are several middle zones. I think it's a mistake to classify everything rapidly as either war or criminal justice. One of the middle zones is this area where you have to deal with targets. And the United States has done the same thing. That we have intervened against using targeted assassinations, using much the same argument that Israel developed in order to justify its targeted assassination against persons who intended to engage in terrorist attacks.
I told you we'd keep you awake.
I think we should hear from Noah on the targeted assassinations. I'd love to respond, but he's certainly the subject matter expert on international criminal actions of that kind.